Creating and protecting your own certification program. Oh man, it is so exciting when you have mastered a method, whatever that method is, and you're ready to expand your business by certifying other coaches or other professionals to do things the way that you know work. So if you've mastered a unique coaching methodology that has transformed your clients in some way, and you want to train other coaches on how to do that, creating a coaching certification program is a very cool next level thing to do in your business. So in this video, I'm going to talk you through all the little legal check boxes to think through when you're developing that certification program, including IP protection, contracts to have in place, and how they protect your certification program, compliance issues, so think privacy and marketing, and enforcement. All right, let's go. So first, intellectual property protection. This is the big one. You might want some trademark protection for the program name. Now, this is the program name, not the certification name. They're a little bit different. Trademark protection for the certification name is very cool. So you have seen certification marks. They're different from trademarks. And you've seen things like Certified Organic or Energy Star or Rainforest Alliance Certified, that kind of stuff. Those are certification marks. That doesn't say I am selling products under a certain logo or brand the way traditional trademarks do. It is something that an independent body looks and evaluates other products and services to say, they check all these boxes, or no, they don't check all these boxes. Certification mark says, hey, this product or this service meets certain standards. Now, here's the trick. You can't use the exact certification mark as a trademark. So here's an example of good housekeeping. They have this good housekeeping certification for all kinds of stuff. Good housekeeping doesn't sell the things that they certify. They don't offer those things. They're a magazine. So you can't engage in the services that you're certifying. You might have to create a separate entity to do that. And you can't certify yourself. Certification marks are based on the premise the owner is an impartial third party that's evaluating whether you fit into this criteria. I'm going to stop here and explain one more thing. So we've talked about trademarks. We've talked about certification marks. Checking those boxes, yes, they qualify. There's also collective marks, which is different again. A certification mark says, hey, this product meets all of our criteria for certified organic. A collective mark says, this person is part of this club. They're in this club. Do you see the difference? So it might be something that you're thinking about. If maybe a certification mark is too complex, you don't want to set up a separate entity, all that stuff. Maybe it's a collective mark that you want to offer that someone can put on their website after they go through your program. All right, we talked about certification marks and trademarks and collective marks. Let's talk about copyright protection. The parts of your certification program like worksheets, videos, tech, marketing guides, pricing guides, templates that you offer in the certification program, your website, your sales copy, all that. What isn't protected is just the idea for the certification program. Also, any facts. Frankincense is good for this. Vitamin C is good for this. Those are facts that you can't protect because they're not exclusive to you. What you can protect is your expression of the idea, worksheets, program materials, all the stuff that you flesh out and create in your own words. Okay, we talked about intellectual property. Let's talk about contracts next. Here are the types of contracts you might need. First, definitely some enrollment terms and conditions. This is for the students enrolling in your program. It kind of establishes rules for code of conduct for any group aspects of the program. Refund protocols, ding ding, you want to make sure those are extremely clear. Maybe they don't get certified at the end and they want a refund. Well, they've gone through the program, so if they didn't pass a test or do something that they needed to do in order to get certification, they don't get a refund. I don't know, it's your choice, but either way, the policy needs to be clear. IP ownership, which of your materials they can use in their own coaching and their own business, and which are your property. Maybe you want to require that they have copyright notices on those materials if they hand them out in their own business. And make clear any ongoing certification requirements. So how long does the certification last? Do they have to pay a fee in order to continue to be certified year after year? All of those things are super important in terms of enrollment and setting expectations and boundaries with those people enrolling in your program. Next is an independent contractor agreement. You'll want to take inventory of all of the support that you're going to need in order to get the certification program off the ground. So web or branding design, copywriting, a community manager, social media marketing, and any other team members that you'll need support from. Finally, an affiliate agreement. If you're going to be offering any kind of affiliate marketing or affiliate opportunities to other people in your network to help sell this program, you want an affiliate agreement in place, making those expectations and boundaries clear. We talked about IP, we talked about contracts. Now, let's talk about regulatory requirements and legal requirements. Ooh boy, don't worry, it's fun. Okay, privacy-wise, I'm going to go through this quickly because you're probably familiar with the GDPR. That shook things up in 2018. The CPRA. These are all laws and rules and regulations when it comes to collecting data from people that visit your website. You've got to let users know the types of data you're collecting, how you're collecting it, and how you're using it. Consent is the most common basis for collecting someone's information, literally opting in and checking the checkbox. Legitimate interest is another. For example, if someone gets a ticket to a webinar, they might have a legitimate interest in more in-depth education on whatever your webinar went in. All of this stuff is covered usually by a privacy policy. Okay, got privacy out of the way. Now let's talk about advertising and social media requirements. This one is governed by the FTC. You must use disclosures and disclaimers, especially when there are affiliates working with you to boost this thing and make sure that they are using the proper disclaimers and disclosures, showing that there's an affiliate relationship there. What's the penalty for not using disclaimers and disclosures when you need to? About $43,000 per violation. So yeah, that's important. And then obviously all advertising and marketing copy should be completely truthful and not at all misleading. Email marketing requirements. Again, accuracy is key. All copy should be truthful, not misleading, including the from and subject line. I have noticed a trend recently where people do RE in the subject line of a marketing email. To me, that's misleading. It's misleading to suggest that you've already been in email communication with this person in a back and forth. Just saying. You must have a physical address listed at the bottom of your marketing emails. That's a legal requirement. And you must have a way for people to unsubscribe, and you must honor those unsubscribe requests. A lot of platforms have this built in. Back to disclaimers. So disclaimers I talk about as the caution wet floor sign for your content. The very obvious, hey, this is a disclaimer over here. It covers yourself. One context that often goes overlooked when we're talking about disclaimers is testimonial disclaimers. Using social proof for people who have already gone through your program is a great marketing tip, but it's important to make sure you're not implying that there are some kind of guaranteed results because you're using these testimonials. So, results not guaranteed. Easy. Obviously, sponsored post or affiliate link disclaimers are types of disclaimers, and medical related disclaimers. I am not a licensed medical professional. Please seek out a trusted provider before making health related decisions, whatever. Finally, enforcement. Protect that IP. If your program were an acai bowl, the IP would be that purpley acai base. Without it, you've got nothing. If a student copies your content and you don't enforce your rights, you could lose them. And/or other students could see what this person is doing and think that they can do it too. You also want to crack down if you're doing the certification trademark route. You want to crack down on anyone who's using that certification mark that isn't actually certified. And then enforcing if a student in one of the group spaces is acting inappropriately somehow. This protects the integrity of your program and it protects your students too and builds that trust with them. So, conclusion, protect the IP, acai bowl reference, consider trademark protection for that certification mark or collective mark if you want that membership kind of protection. There are some really specific rules for the certification mark, so if you're interested in that, make sure and talk to an attorney. Protect your relationships. That means relationships with your students and any support you get from contractors or team members. Make sure and follow the rules. No $40,000 fines for you. Obey the FTC and play by the rules when it comes to privacy too. And don't sit on your hands when someone does you wrong. At least talk to an attorney so you can understand your rights and your options. I'm your woo-woo spiritual friend Maria, who just happens to be a lawyer for coaches and healers. I hope that you found this super valuable if you're thinking of starting your own certification program. And hey, head to my website, thelegalapothecary.com, to find my latest free resources for coaches and healers.